Hello and good afternoon, everyone. This is Frank McNally, Public Spend Forum and GovShop. We have a very important, we think, webinar for you this afternoon on force majeure and understanding your rights and responsibilities as a government contractor impacted by COVID-19.
One disclaimer up front that I'll put in for everybody. While this is a panel of attorneys, we are not a panel of your attorneys. We are going to discuss some very important items and their legal significance. However, nothing should be constituted as direct legal advice to anybody listening today. You should consult with your own attorney on matters that are specific to your issues and contract issues. And hopefully stuff that you learned today will be a good starting point for that. So John, if we could pass it over to you.
Sure, thanks, Ben. Glad to be here. Yeah, we're not your lawyers yet, but we would be happy to talk with you about the situations you're encountering. And we're getting a ton of questions on the impacts of COVID-19. So I think this is a really timely topic. I'm a partner in the government contracts group at Majeure, and we're representing small, medium, and large contractors and everything you deal with. And unfortunately, right now, this is really issue number one, isn't it?
And so this one for John. John, in the federal contracting context, can you explain the concept of excusable delay? And specifically, does 52-249-14 apply to this current situation?
Yeah, sure, Ben, thanks. And fortunately, the first question there you gave me is pretty easy because an excusable delay is exactly like it sounds. So it's a delay in your ability as a contractor to perform the contract, and that delay is excusable, meaning you as the contractor are not going to bear the responsibility for the delay. So in other words, and Elizabeth was mentioning a couple of the other clauses, and we've given you in the chat box the citations to these clauses that operate to essentially excuse you from defaulting on performance of the contract when these excusable circumstances arise. And fortunately for this particular circumstance, epidemic and quarantine restrictions, you'll see in the clause here on the slide, are two of the circumstances that would represent an excusable delay. So if you are prevented from performing the contract per the schedule, the deliverables, whatever it was that you're supposed to do by when you're supposed to do it, if you are experiencing one of these circumstances, and we're all experiencing some very unique and crazy circumstances right now based on this epidemic, then that should prevent you from being in default of the contract. The delays you may experience should be excusable. Now, Ben mentioned that, and Elizabeth as well, that there are a lot of different clauses that address this. So we've got 52-249-14 up here. Elizabeth mentioned a couple others. There are a few more. It's really important then that you have to look in your contracts to understand what clauses are in your contracts. That's first and foremost. Ben mentioned the idea or the concept of reading a clause into a contract. A court could do that under what's called the Christian doctrine. If it's a mandatory clause and it's something that is so significant or deeply ingrained in procurement policy that it should have been in your contract and it was just a mistake, frankly, that it was left out. I think these types of clauses we're talking about here, excusable delay provisions, default provisions, should be read into your contract if they were left out. But it's important to start there. What's in your contract? So that's one of our exercises right now as contractors, is we got to understand the terms that we're operating under, and then we'll know how to move out from here in dealing with these really unique circumstances that we're encountering. The other point I want to make on excusable delays is that it's not good enough just that you've identified this clause in your contract and that we all know we're having an epidemic. In other words, like COVID-19 is not just a mic drop moment for you on your contract, and you can feel free to get the deliverable turned in whenever you get around to it. You need to have detailed documentation to support how this epidemic is impacting your performance. So that could be documenting like which particular staff of yours are affected or how your overall company and office and personnel are impacted. It could be in your supply chain, the delays that are being experienced, and that there's no alternative means for you to perform the contract, that you have no workaround. So you have no choice but to have this delay. Or perhaps there is a workaround, but it might be a more expensive means of performance, in which case you might have a claim or a request for equitable adjustment to increase the cost of the contract, as Elizabeth alluded to. I mean, that's really, I think, what a lot of contractors need to be preparing for right now. And this is, again, where having good documentation, details of exactly how you're being impacted are going to go a long way towards both excusing the delays and avoiding a default, but also potentially establishing the basis for an REA or a claim down the road.
John, what immediate actions should vendors be taking today to protect themselves in this environment?
Yeah, thanks, Ben. I mean, I think the first thing, and it probably goes without saying, is to take care of your people. Make sure that you're providing a safe workplace, that your people know to stay home if they're sick, that they understand what your telework policy is. I mean, there are a lot of HR employment issues that I think is job number one for contractors right now. But a close second, or maybe a 1B, is, how do we keep things going on our contracts, and how do we line up our obligations to our employees with our obligations to our customers? And we've talked about it already, but I think it's worth reiterating. The number one point there is to look at your contracts, to understand the rights and obligations, which clauses are included, et cetera. And we got a question from one of the attendees about if you're performing primarily on task orders, and those tend to be maybe kind of thin in terms of incorporated clauses. I would expect in all cases that these task orders are subject to the terms and conditions in the master IDIQ contract. So I would go to your master IDIQ contract and look for, what clauses are included. Is there, which default clause is it? Is there a stop work order provision in the contract? Is there an excusable delay provision? It's really important to understand, what obligations and rights you have right now. And that goes to another question that we got about sort of a unique circumstance where you might be an essential contractor. And the questioner asked about a specific DFARS clause that requires, if you are an essential contractor, you have to have a plan in order to tell the government how it is that you're going to keep these essential services going during the crisis, in this case, the epidemic. So there is a part of that clause that gives you the ability to go to the customer and say, look, even though I'm providing essential services and I'm supposed to give you a plan if I'm going to keep things going here, I've got some challenges. And, the government, at least the way the clause is written, should work with you towards finding a way that you balance the challenges you're facing with the need to keep the services going. But that really requires having a conversation with your customer. So I think that's the next point on the list, is talk with your customers, talk with your contracting upstream and downstream partners, vendors, subcontractors. I think communication is really key right now. And when you're talking with your customers, are you going to have a work stoppage? Is there going to be an actual stop work order issued, or is there constructively a stop work order because you can't access the facilities anymore? How can you work around these challenges, especially in the event that you are a contractor that provides essential services, or even if not essential, the objective is to keep the work going. So how are we going to work around that? The maybe office closures or people having to telework, et cetera. Communicating It's really important you don't make those decisions in a vacuum, that you do that with your customers and your partners in the loop. Because of the potential for claims and REAs here, these communications with the customers and upstream and downstream partners will also really help to set the stage for potential claims that you might have. And with that in mind, my last point here would be to document everything. Keep good records of these communications and what the government's instructing you to do, what you're hearing from subcontractors about availability of supplies or workforce, potential increased costs that you might be encountering as a result of having to shift gears and how you were performing, try a new approach in order to keep the lights on, so to speak. All of that could be the basis for a claim or a request for equitable adjustment. And knowing the rights in your contract, so going back to one of my first bullet points, that also impacts the timing of when you submit a request. So under the some clauses, you may need to submit a request for adjustment within 30 days after the work stoppage ends. So you want to make sure you understand the timing requirements around, your contract clauses that might give you the right to request additional money. And I guess one more point, I did say that documenting was my last point, but for the small businesses out there, keep in mind that the SBA, the Small Business Administration, has a few ways that they might be able to help. They have what's called procurement center representatives, or we call them PCRs. And these folks can help to intercede on your behalf with procuring agency officials if you're running into any challenges in terms of how to handle the situation and what's going on your contract. Especially if it's an 8A contract, then you have the SBA 8A office that is uniquely involved with the way those contracts are awarded. So keeping SBA in the loop and seeking help from them if you need it is one way to use them. And they also have an Office of Disaster Assistance that provides disaster assistance loans. And they can be up to $2 million that can be used to pay for fixed debts, payroll, things like that at a fairly low interest rate and can be up to 30 years depending on the specifics of your situation. So for the small businesses out there, keep those additional points in mind. I think what we're probably going to start seeing coming up later this week, I think we've already seen some of it today, is that there are going to be more government sites that are going to mandatory telework as well. So it's been something that's, I think, largely to this point been led by the contractors and the commercial sectors getting out in front of teleworking first. So there was an article in the Washington Post this morning about how in that environment, isn't it interesting that all the government folks are still having to show up to work? And I think that's been answered here today. I've heard just anecdotally from my wife who works for the government that they're now on mandatory telework for the next 3 weeks or so. So I think we are going to have contractors like this question on the slide that are either constructively or actually facing a stop work order. And so then that raises challenging questions, just like you probably had to encounter a little over a year ago with the last government shutdown. What do you do with your people when the work is shut down? Do you have something else they can do in the meantime? How long do you keep them idling until you have to lay them off? And I think that's going to have to be sort of almost a day by day question in some instances, and for some contracts, and depending on the unique skills that people on your team have, it might make sense, and you may have the basis for an idle labor claim that you paid essentially to keep them on standby for the government. Other types of personnel and other types of contract work that people may be doing would not as readily justify an idle labor claim. So they may have to look at layoffs sooner than than other folks. I think that unfortunately this is where we're going to be for a lot of the contractors.